All rise. Vive levé. The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience du tribunal pénal international pour l'ex-Yougoslavie est ouverte.
Good afternoon, everybody. Madam Registrar, could you call the case, please?
Good afternoon, Your Honors. This is case IT 0587/1A, the prosecutor versus Vlastimir Djordjevic.
I thank you. Mr. Đorđević, I address myself to you. I want to make sure before we proceed that you can follow the proceedings in a language that you understand. Thank you. I see that. Was your microphone on? Because your reply didn't register.
Excuse me, the microphone was not on. I can follow everything in my language.
Right. I thank you. I would like now to ask the parties to identify themselves, starting with counsel for the prosecution.
Good afternoon, Your Honors. My name is Daniela Kravitz, together with my colleagues Kyle Wood, Priya Gopalan, and our case manager, Colin Narod, for the prosecution. Thank you.
Thank you. I turn myself now to counsel for appellant Đorđević.
Good afternoon, Your Honors. My name is Dragoljub Đorđević. I'm lead counsel. Together with me today is co-counsel Veljko Đurđić and legal assistants Ms. Mari O'Leary, Mr. Aleksandar Popovic, and Mr. Russell Hopkins.
I thank you very much. Pursuant to the scheduling order issued on 15th November 2013, the Appeals Chamber today delivers its judgment in the case of the prosecutor versus Vlastimir Djordjevic. I shall be reading now a summary of the central findings of the Appeals Chamber. The summary does not constitute the official and authoritative judgment of the Appeals Chamber. The official judgment is rendered in writing and will be distributed to the parties at the close of this hearing. This case relates to events which took place in Kosovo between the 1st of January and 20th of June of the year 1999. Throughout that time, Mr. Đorđević was the Assistant Minister to the Serbian Minister of Internal Affairs, which I will be referring to the MUP, and Chief of the Public Security Department of the MUP, the RJB. The trial chamber issued its judgment on 23rd February 2011. It convicted Mr. Đorđević under 5 counts for the crimes of deportation, other inhumane acts consisting in forcible transfer, and persecutions on racial grounds as crimes against humanity, as well as murder as a crime against humanity and also as a violation of the laws or customs of war. The trial chamber found that Mr. Đorđević participated in a joint criminal enterprise with the purpose of modifying the ethnic balance in Kosovo to ensure Serbian control over the province. This purpose was achieved through the commission of these crimes. The trial chamber also found that Mr. Đorđević aided and abetted the same crimes. The trial chamber sentenced Mr. Đorđević to 27 years of imprisonment. In his appeal, Mr. Đorđević raises 19 grounds of appeal, challenging the findings of the trial chamber, and the prosecution raises 2 grounds of appeal. The appeals chamber heard oral submissions by the parties on 13th May of last year. I will now proceed to summarize the appeals chamber main findings on Mr. Đorđević's appeal before turning to the prosecution appeal. In his first ground of appeal, and in grounds 3, 4, and 5, Mr. Đorđević raises a number of arguments in relation to the joint criminal enterprise. In particular, he challenges the trial chamber's findings concerning the existence of the joint criminal enterprise, the timing and the members of the joint criminal enterprise, the plurality of persons, and the nature of the common plan. The appeals chamber finds that Mr. Đorđević has failed to demonstrate that the trial chamber erred in its conclusions on these issues. The appeals chamber therefore dismisses Mr. Đorđević's first, third, fourth, and fifth ground of appeal. In ground 2, part of ground 6, and ground 8 of his appeal, Mr. Đorđević submits that there are cogent reasons for the appeals chamber to depart from its jurisprudence on various aspects of the law on joint criminal enterprise. Specifically, he argues that the appeals chamber should depart from its previous decisions finding that joint criminal enterprise as a form of liability exists in customary law, and that convictions for specific intent crimes can be entered on the basis of liability under the third category of joint criminal enterprise. The appeals chamber finds that Mr. Đorđević has failed to demonstrate the existence of cogent reasons for such departure from its jurisprudence, and therefore dismisses Mr. Đorđević's second ground of appeal, the relevant part of the sixth ground of appeal, and the eighth ground of appeal. In the remainder of his sixth ground of appeal, Mr. Đorđević submits that the trial chamber failed to establish the required link between the joint criminal enterprise members and the physical perpetrators of the crimes. In its judgment, the appeals chamber also rejects this argument, which it finds unfounded, and accordingly dismisses ground 6 in its entirety. Under his 7th ground of appeal, Mr. Đorđević submits that the trial chamber erred in concluding that the crimes of murder and persecutions fell within the joint criminal enterprise. He argues that the trial chamber failed to establish that each member of the joint criminal enterprise shared the requisite mens rea for these crimes. The appeals chamber finds that the trial chamber made all the necessary findings and that Mr. Đorđević has failed to show that no reasonable trier of fact could have reached the same conclusion as the trial chamber. Accordingly, ground 7 is dismissed. Under his 9th ground of appeal, Mr. Đorđević makes a number of submissions divided into 8 subgrounds concerning his participation in the joint criminal enterprise. He argues that the trial chamber committed several errors of law and fact, which resulted in a mischaracterization of his conduct and improperly linked him to the joint criminal enterprise. For the reasons set out in the judgment, the appeals chamber, Judge Tutsmukhamedov dissenting, in part, is not persuaded by Mr. Đorđević's arguments. Therefore, Judge Tutsmukhamedov dissenting in part, the 9th ground of appeal is dismissed in its entirety. Under his 10th ground of appeal, Mr. Đorđević submits that the trial chamber committed several errors of law and fact in assessing his mens rea for the joint criminal enterprise liability. He advances numerous arguments to the effect that the trial chamber erred in finding that he possessed the criminal intent for the joint criminal enterprise. One of his arguments is that the trial chamber erred in relying on certain reports by Human Rights Watch in inferring his knowledge of the crimes. The appeals chamber agrees with this submission. However, for reasons outlined in the judgment, the appeals chamber considers that this error does not impact the trial chamber's conclusion on Mr. Đorđević's knowledge of the crimes and its overall conclusion that he possessed the required intent for joint criminal enterprise liability. The appeals chamber rejects all other arguments advanced by Mr. Đorđević in this ground of appeal, as he has failed to show that no reasonable trier of fact would have come to the conclusion that he possessed the required or the requisite intent for the joint criminal enterprise based on the evidence. Mr. Đorđević's 10th ground of appeal is therefore dismissed. Under his 12th ground of appeal, Mr. Đorđević submits that the trial chamber misapplied the definition of civilian and therefore erred in convicting him for the crimes of deportation, other inhumane acts consisting in forcible transfer, and murder. The appeals chamber, Judge Tutsmukhamedov dissenting in part, is not persuaded by any of his arguments. As described in the judgment, the appeals chamber considers that the trial chamber did not err in its determination of the protected status of victims or in its assessment of the proportionality of the attack. Accordingly, Judge Tudzmukhamedov dissenting in part, ground 12 is dismissed. Under his 13th ground of appeal, Mr. Đorđević submits that the trial chamber erred in finding that the crime of deportation was committed with respect to Kosovo Albanians who were displaced from Kosovo to Montenegro. In its judgment, the appeals chamber finds that, consistent with the tribunal's jurisprudence, the trial chamber correctly observed that the crime of deportation can be established by displacement across a de facto border. However, it failed to articulate the basis in customary international law upon which a de facto border could be established in this instance. This, in the opinion or in the conclusion of the appeals chamber, constitutes an error of law. Consequently, the appeals chamber has considered whether the finding that a de facto border existed between Kosovo and Montenegro is supported in customary international law. It has found no such support. Therefore, the trial chamber erred in concluding that the crimes of deportation and persecutions through the act of deportation were committed with respect to the displacement from Kosovo to Montenegro. For these reasons, the appeals chamber overturns the trial chamber's finding in this respect and grants the 13th ground of appeal. Under his 14th ground of appeal, Mr. Đorđević submits that the trial chamber erred in convicting him for murder in relation to certain crime sites where premeditation was not established. In its judgment, the appeals chamber holds that the jurisprudence of the tribunal has not required premeditation as an element of the crime of murder. That's under Article 3 and 5 of the Statute of the Tribunal. The appeals chamber finds that Mr. Đorđević has advanced no cogent reasons which would justify the appeals chamber to depart from this jurisprudence. Accordingly, his arguments are rejected and his 14th ground of appeal is dismissed. Under his 15th ground of appeal, in part, Mr. Đorđević submits that the trial chamber committed errors of law and fact in finding that the crime of persecutions was established through the destruction of certain mosques. He also submits that the trial chamber erred in the application of the equal gravity test in relation to the underlying act of destruction of religious property. The appeals chamber, Judge Tudzmukhamedov dissenting in part, finds that the trial chamber did not err in these respects and therefore dismisses the 15th ground of appeal in part. The remainder of this ground is addressed in the context of the 17th ground of appeal. Under his 16th ground of appeal, Mr. Đorđević submits that the trial chamber erred in convicting him of the crimes of deportation, other inhumane acts consisting in forcible transfer, murder, and persecutions with respect to several incidents as they were not alleged in the indictment. In its judgment, the appeals chamber finds the trial chamber erred in finding Đorđević responsible for the crime of deportation in relation to 2 incidents, the crime of other inhumane acts consisting in forcible transfer in relation to 2 incidents, and the crime of murder in relation to the killing of 11 individuals at 2 locations, and the crime of persecution in relation to all of these incidents. The details will be set out later on during this hearing, in the latter part of this summary. With regard to all of the other incidents which have been challenged by appellant Đorđević, the appeals chamber finds that he has shown no error. In the light of the foregoing, the appeals chamber grants the 16th ground of appeal in part. Under his 17th ground of appeal and part of his 15th ground of appeal, Mr. Đorđević challenges the trial chamber's findings that the crimes of deportation, other inhumane acts consisting in forcible transfer, murder, and persecutions were established in certain locations. The appeals chamber, Judge Guney and Judge Tuzmukhamedov dissenting in part, finds that Mr. Đorđević has failed to demonstrate an error in this regard. Therefore, Judge Guney and Judge Tuzmukhamedov dissenting in part, the appeals chamber dismisses ground 17 of appellant Đorđević in its entirety and ground 15 in part. Under his 18th ground of appeal, Mr. Đorđević presents 2 subgrounds. First, Mr. Đorđević submits that the trial chamber erred by convicting him twice for the same crimes, once for committing the crimes through participation in a joint criminal enterprise, and again for aiding and abetting these crimes. The appeals chamber is satisfied that the trial chamber only convicted him once for the crimes, but on the basis of 2 modes of liability. The appeals chamber also finds that it was within its discretion, that is, within the trial chamber's discretion, to enter convictions on the basis of more than 1 mode of liability. However, the appeals chamber finds that the trial chamber failed to articulate why both modes of liability were necessary to reflect the totality of Mr. Đorđević's criminal conduct. This amounted to an error of law. The appeals chamber considered that in this case, the criminal conduct of Mr. Đorđević is fully reflected in a conviction based solely on his participation in the joint criminal enterprise. The appeals chamber therefore grants this subground in part and reverses the trial chamber's findings concerning counts 1 to 5 with respect to aiding and abetting. In the light of this finding, Mr. Đorđević's 11th ground of appeal, which raised the arguments in relating to aiding and abetting, becomes moot. His second subground asserts that the trial chamber erred in entering convictions pursuant to Article 5 of the statute for the crimes of deportation and other inhumane acts consisting in forcible transfer and murder, in addition to a conviction for the crime of persecutions through those same acts. In its judgment, the appeals chamber finds no such error. This subground is therefore dismissed. I will now set out the Appeals Chamber findings on the prosecution's appeal. In its first ground of appeal, the prosecution submits that the trial chamber erred in law and in fact by finding that the crime of persecutions through sexual assault was not established. The prosecution argues that the trial chamber erred in failing to find that underlying acts of sexual assault was established in relation to a Kosovo Albanian girl in a convoy in Pristina municipality and 2 young Kosovo Albanian women in Beleg. It further argues that the trial chamber erred in failing to find that the crime of persecutions was established through the sexual assault of 5 women, namely the 3 aforementioned women and witnesses K14 and K20. Finally, the prosecution argues that the trial chamber erred in failing to find Mr. Đorđević was liable for persecutions through these sexual assaults under the 3rd category of joint criminal enterprise. In its judgment, the Appeals Chamber finds that the trial chamber erred in failing to find that the 3 women were sexually assaulted. It further finds that the trial chamber committed an error of law in its assessment of the discriminatory intent of the perpetrators of the sexual assaults. For reasons set out in the judgment, the Appeals Chamber, Judge Tudzmukhamedov dissenting, is satisfied that the sexual assaults of a Kosovo Albanian girl in a convoy in Pristina municipality, 2 young Kosovo Albanian women in Beleg, and witnesses K14 and K20 were carried out with discriminatory intent and amounted to persecutions. Furthermore, the Appeals Chamber, Judge Tudzmukhamedov dissenting, finds that it was foreseeable to Mr. Đorđević that persecutions through sexual assaults might be committed, and that he willingly took the risk when he participated in the joint criminal enterprise. It therefore finds Mr. Đorđević responsible for the crimes of persecution under the 3rd category of joint criminal enterprise. In the light of these findings, the Appeals Chamber, Judge Tudzmukhamedov dissenting, grants the prosecution's first ground of appeal, and Judge Kuney dissenting enters a conviction under count 5 for persecutions through sexual assault as a crime against humanity pursuant to the 3rd category of joint criminal enterprise. I will now turn to sentencing. Mr. Đorđević, in his 19th ground of appeal, and the prosecution in its 2nd ground of appeal, challenged the sentence of 27 years imprisonment imposed by the trial chamber. The Appeals Chamber finds that it was within the discretion of the trial chamber to consider Đorđević's role and position as an aggravating factor. However, the trial chamber committed a discernible error by failing to assess whether Mr. Đorđević abused his position of authority. The Appeals Chamber therefore grants Mr. Đorđević's 19th ground of appeal in part. However, it finds his other arguments unpersuasive and dismisses them. The Appeals Chamber is also not persuaded by the prosecution arguments and therefore dismisses its second ground of appeal. In the light of the above, and in its overall assessment of the circumstances of the case, the appeals chamber finds that a reduction in Đorđević's sentence is appropriate. In particular, the appeals chamber considers that the convictions entered by the trial chamber, which have now been overturned on appeal, outweigh the new convictions entered by the appeals chamber, not only in terms of number of victims, but also by way of Đorđević's level of responsibility. By this, however, the appeals chamber by no means intends to suggest that the crimes for which Đorđević has been convicted on appeal are not grave. Considering the foregoing and the circumstances of this case, including Mr. Đorđević's age, the appeals chamber will be reducing his sentence. Disposition. I will now read out the disposition of the appeals judgment. Mr. Đorđević, will you please rise? For the foregoing reasons, the appeals chamber, pursuant to Article 25 of the statute and Rules 117 and 118 of the Rules of Procedure and Evidence, noting the written submissions of the parties and their oral arguments presented during the appeal hearing of the 13th May 2013, sitting in open session, with respect to Đorđević's appeal, grants Đorđević's 13th ground of appeal and reverses his conviction for deportation, count 1, and persecutions through deportation, count 5, with respect to the displacement of individuals to Montenegro from Peć on 27 and 28 March 1999, and from Kosovska Mitrovica on the 4th of April 1999. Grants, in part, Đorđević's 16th ground of appeal and reverses his conviction insofar as they relate to: first, deportation, count 1, and persecutions committed through deportation, count 5, at Kladenica in Srbica, Skanderaj municipality between the 12th and 15th April 1999, and Suvarijeka between 7th and 21st May 1999. Second, other inhumane acts consisting in forcible transfer, count 2, and persecutions committed through forcible transfer, count 5, at Brocna and Tušilje in Srbica, Skanderaj municipality between 25 and 26th March and on 29th March 1999 respectively, and Kuška in Peć municipality on 14th May 1999. Third, murder as a crime against humanity and as a violation of the laws or customs of war, counts 3 and 4, and persecutions committed through murder, count 5, of 2 elderly men at Podujevo town in Podujevo municipality on 28 March 1999, and of 9 men at Mala Kruša in Oraovac municipality on the 25th March 1999. Grants in part Đorđević's 18th ground of appeal, reverses his convictions for counts 1 to 5 on the basis of aiding and abetting, and consequently declares moot his 11th ground of appeal. Grants in part Đorđević's 19th ground of appeal and finds that the trial chamber erred in considering his position of authority as an aggravating factor. Dismisses the remainder of Đorđevic's appeal, Judge Guney dissenting with respect to Đorđević's 17th ground of appeal in part, and Judge Tuzmukhamedov dissenting with respect to Đorđević's subground 9, E, F, and G, and in part 12th, 15th, and 17th ground of appeals. Affirms all other convictions pursuant to counts 1 to 5. With respect to the prosecution's appeal, grants Judge Guney and Judge Tuzmukhamedov dissenting in part the prosecution's first ground of appeal and finds Đorđević guilty pursuant to Articles 5 and 7.1 of the statute of the crimes of persecutions through sexual assaults as a crime against humanity. Pursuant to the third category of joint criminal enterprise in relation to the sexual assaults of witness K20 and the two young women in Beleg, witness K14 and the Kosovo Albanian girl in a convoy, and revises Đorđević's conviction with respect to count 5 accordingly. Dismisses the prosecution's second ground of appeal. Sets aside the sentence of 27 years of imprisonment and imposes a sentence of 18 years of imprisonment, subject to credit being given under Rule 101C of the Rules of Evidence and Procedure for the period he has already spent in detention. Orders, in accordance with Rules 103C and 107 of the rules, that Vlastimir Djordjevic is to remain in the custody of the tribunal, pending the finalization of arrangements for his transfer to the state where his sentence will be served. Judge Guney appends a partially dissenting and separate opinion. Judge Tuzmukhamedov appends a dissenting opinion. Mr. Đorđević, you may be seated. Registrar, you're free to distribute copies of the judgment to the parties now. Thank you. Before concluding the hearing, I would like to briefly thank everyone in this courtroom and outside this courtroom who have helped us throughout these proceedings over the past months and 2 years, without whom and without whose help we wouldn't have come to this stage today. In particular, I would like to thank my colleagues sitting with me here today for all their help, counsel, advice, and cooperation. I will now conclude this hearing. The appeals chamber stands adjourned.
All rise. Vive le